Hello, today we're going to look at contracts and the formation of a contract. In particular, we're looking at offer and invitation to treat. Man as a species has always traded goods for either money or for other goods or for a promise or for some benefits that he sees in the future. Lawyers call this agreement a contract. In this lesson, we will be looking how a contract is formed. The objectives for this lesson on the formation of a contract are to be able to recall and label the elements necessary in the formation of an offer, to be able to examine and consider and determine whether an offer has been made in any given circumstance, and you should also be able to identify what is and is not an invitation to treat compared to an offer. Bartering and bargaining are the origins of contracts. I will give you some fish if you will give me some wheat, because I've got lots of fish, but I don't have bread and I need wheat to make my bread. And the other person, I've got lots of bread, but I don't have much protein. Can I have your fish for some of my crop of wheat? You see how it's done. Each party needs something. The key issue is something for something. Now, the something is specific to the other party and is sufficient for the other party. What does that mean? Well, for example, you will provide labour and you will expect at a certain time after a month to be paid for the labour you have provided on an agreement which we call a contract of employment. Contracts are about doing deals, being able to bargain. For example, you do a deal, say someone offers you £1,000 for your car. You say, no, I reject that offer. I would take £3,000. And the other person comes back and says, £3,000 is too much. Would you take £2,500? And you reply, yes, I'll take £2,500. We have a deal. At this point, the contract is complete. There has been an agreement, an offer and acceptance, and the parties know what has been offered and what is accepted. But it isn't always that easy. What happens if you have two cars and you think he's talking about the other car and he is in fact talking about your more expensive car? Then there's issues on what was offered and what was accepted. Do you see? But we do bargain. We go to car boot sales. Your parents may go to car boot sales and you lay out goods. You don't sometimes even put prices on those goods, and people will bargain even if there is a price on the goods and reach an agreement or not on the price which they hand over to get the goods. That's a contract. Another form of contract, if you like, is auctions. People bidding for a vase, like this example here. people are bidding for this vase. It's a very special vase, and they bidding, and the highest bidder will get the vase when the hammer hits here and the contract is complete. So the auctioneer is waiting and seeing if he can get higher bids, and eventually, say this man here bids the most and no one outbids him, and the hammer will go down, and the auctioneer, when he puts the hammer down, that completes the contract. In this case, we've got a rather nice looking Volkswagen Beetle, rare classic cars, and the old lady owns the Beetle. Just point out which one's the old lady. And the young man is trying to buy this classic car. Unfortunately, the car has some problems. But nevertheless, he makes an offer. Her response is, "Speak up, dear, I can't hear you." When he makes an offer which she doesn't hear, would that be capable of making a contract? No, it wouldn't, because there's no clear idea of what's been offered for what. His intention is to offer for this classic car. She doesn't know that because she can't hear him. In this case, while an offer's been made, we know the offer's been made by the young man for £50 for the car, she hasn't heard the offer and she's not accepted it. But once the old lady understands what is being offered, then what are her options? There are 3 possible options. They really must sort that exhaust out. So the old lady understands what's being offered. Let's look at her options. Option number 1, accept the offer and the contract would come into existence. The young man's made an offer, she knows what the offer is, and she accepts the offer. So we have offer and acceptance. Option number 2, reject the offer and stop the negotiation. No, I don't want to sell my car. The negotiation stops. And the third option, option number 3, reject the offer and make a counter offer, which starts a new round of negotiation. I reject your offer of £50 and I make a counter offer of, well, we'll see. Here we are with the old lady, and she rejects the offer of £50, which ends his offer, and she puts a counter offer of £100 to the young man. What are his options? Well, he's got 3 options, hasn't he? Option number 1, to reject her counter offer of £100. He would do that by saying something like, no, £100 is too much. Or accept her offer. Yes, I accept £100 and I will give you £100 for the car. Or he can make a counter offer. No, £100 is too much. I will pay you £75. So I've gone up by £25. So as you can see, in each round of bargaining, offers can be made, and when a new offer is made, it ends the old offer because it stops the old offer, because effectively if you put a counter offer, you're rejecting the first offer and you're putting forward a new offer to the other side, and they have to respond to that either to accept or reject it. So that would be the second round of negotiation, and there would be no agreement until there was an agreement between both parties. Both parties, in this case, would need to agree the price. And once that's happened, then the contract comes into existence and not before. So, what is first part of an essential agreement to make a contract? Well, clearly that's an offer. If there's no offer, you can't agree anything, can you? For example, would you consider selling your car, and if so, what would you want for it? Is that making an offer? No. As we can see with the cross here, it's an inquiry. There is no offer made. You don't know the price. You know that the person might be interested in buying your car, but certainly that person hasn't made an offer. They're merely inquiring whether you would consider selling your car, and if so, what would be the price? Another example. I would pay good money for your car. What do you want for it? He's putting forward an invitation to treat, an invitation to begin a bargaining process. Again, it's not a formal offer. It's merely an inquiry, an invitation to start a negotiation. We're now looking at the case of Harvey and Facey. Mr. Harvey telegrams Mr. Facey, will you sell us Bumper Hall pen, telegraph lowest cash price? Mr. Facey replies, lowest price for Bumper Hall pen, £900. You have to remember that Jamaica in 1893 belonged to the British Empire, and English law applied in Jamaica, or normal contract law applied. Mr. Facey's reply, lowest price for Bumper Hall pen, £900, was a small fortune in those days. It was a considerable sum of money. You could buy 9 big houses in London for the same amount of money. Mr. Harvey telegrams back to Mr. Facey, we agree to buy Bumper Hall pen for the sum of £900 asked by you. Please send us your title deed in order that we may get early possession. We're at this point, Mr. Harvey is assuming that they have a deal and that the price is £900. Look at the wording and see, is he right to assume that they have a deal, that a contract has formed, there has been offer, and there has been an acceptance of the offer? Let's go back to the first line. Will you sell us Bumper Hall pen? Telegraph the lowest cash price. Well, that's not making an offer, because they didn't say how much they were willing to pay. It's an inquiry on whether Harvey could buy Bumper Hall pen and at what price he'd be willing to accept. Not necessarily from Mr. Harvey, but what price would he be willing to consider for the property? Mr. Facey replied, lowest price for bumper haul pen 900. Note here that Mr. Facey didn't say, I'm prepared to sell you bumper haul pen. He's just giving them a value for the property. Lowest price for bumper haul pen, £900. Mr. Harvey telegraphed back to Mr. Facey, we agree to buy bumper haul pen for the sum of £900 asked by you. Please send us the title deed in order that we can get early possession. Mr. Harvey is assuming that Mr. Facey has accepted an offer of £900 and that there is a contract. We can say from that Mr. Harvey is prepared to pay £900. He's offered £900 for bumper haul pen to the owner, Mr. Facey. Mr. Facey didn't sell the haul for that price and argued he was simply supplying information and that he'd not made any acceptance and that no formal offer had been made when they were inquiring about the value of the property. The Privy Council, which is the House of Lords, agreed with Mr. Facey. When the Privy Council looked at the evidence, they looked at the wording and whether the initial conversation was a request for information and not an offer. Well, they decided it was a request for information. Therefore, when Harvey telegrammed acceptance, what was he accepting? Because Mr. Facey had never offered to sell the property for £900 to Mr. Harvey. So there was nothing Harvey could accept. On this slide, I've tried to set out how to do a reminder. You can put them in slides or you could print them off as cards as a memory jog to help you remember cases. What it does is it puts relevant facts together with the issue that the case was about together in a very short summary. And if you do it yourself with putting relevant pictures and writing, you're more likely to remember it. It's partly a learning process because picture, repeating, and then looking at it again reinforces your knowledge and memory. So I would recommend as a tip that you should set up a card index of this similar way for all the key cases that you've got to learn. We're just looking at a few examples of different types of contracts and transactions. The first example I give is tickets. You ticket to ride the bus or the train or ticket to go and see a show. There's been an offer and there's been an acceptance. The offer usually is to watch a show or to get on the train to go from A to B, and the acceptance is when you pay the money to do that and you get a ticket back with terms and conditions on. We have work situation where there's an offer for a job and someone takes up that offer for a job and applies, and they've accepted, and then the employer sends them a formal job offer, and they accept that job offer, and the terms and conditions are agreed. A license. Well, you can have the thing called a license. You can pay for a license commercially. For example, you may have the license to supply one particular product in a country that you bought from the manufacturer, of the sole manufacturer of that property, and you've got sole right to sell those goods in that country, and that's got considerable value. Or you can have a license that you've purchased which authorizes you to have a franchise and have the name McDonald's on your franchise. Normal trade, buying and selling. These are all contracts. Contract for services, contract for legal advice, contracts for taxi delivery, contract to have your hair cut. They're all potential contracts for services. These are just some examples. Well, we've identified that for a contract to exist, there needs to be an offer, not a simple request for information. That's Harvey and Facey. The difficulty arises is distinguishing between an offer and an invitation to treat. Let me explain. Sometimes an invitation is made to open negotiations or discussions without a formal offer being made. We will discuss this after we've taken the break from this first part of contract law and we go into the second part, which will deal with invitations to treat. Thanks for listening. My name's Tony Hughes. Don't forget to subscribe. This is all free, and if you've got any comments, don't hesitate to put them down. Cheers, bye bye.